Hey guys, welcome back to another edition of the Art and Business of Writing podcast. I'm your host, Chris Jones, where today I am stoked to bring you Gordon Firemark. Gordon is a legal expert. He's an attorney who has been practicing law since 1992, so he's been in the game for about 25 years, and his specialty is focusing on entertainment, theater, and media law. And so today we're going to have a great conversation for you just about things that you need to think about as a writer, as an author, as a blogger, and even a podcaster on the legal end. So without further ado, I want to bring you Gordon because you're going to love this interview. Gordon, welcome to the Art and Business of Writing.
Hi, thanks for having me.
Yeah, no, great to have you. You are the first attorney, and I can't tell you how thrilled I am because writers have so many legal questions, and today I'm hoping that you can cross a lot of T's and dot a lot of I's for it.
Well, I hope so too. And let me just say, anytime you get free legal advice, it's worth exactly for it.
Exactly. So before we jump into the interview, I'd like for you to expand upon the bio a little bit. Tell us more about yourself, what you do, how you got started.
Well, I have a sort of an interesting and peculiar background. All lawyers probably have the ability to say that, but I got involved in theater as a very young kid. Actually, my first exposure, I was about 5 years old. I was in kindergarten, and I saw a rehearsal of the high school kids' local play, and that just hooked me, and I was reeled in. And so all my life, that's sort of what I've been chasing is the theater and entertainment stuff. And in high school and college and into my professional career, before I went to law school, I was working as a sound technician. So got real used to working with microphones and making announcements, all that kind of stuff, and mixers and recording. And so, once I became a lawyer, it was sort of natural to combine my interests in entertainment and the law. And also then I started a podcast of my own called the Entertainment Law Update Podcast. And I've been doing that for about 10 years now with a co-host. And when we started, I realized there's nobody who has written anything or talked about the law of podcasting. And so I took it upon myself to do that. I wrote a book, and I am holding myself out there as the podcast lawyer.
Very cool. So tell us about the book a little bit.
Well, basically the whole premise that I take here is that podcasting is very much content creation, media creation, like other media, like broadcasting or journalism or television, radio, and all those kinds of things. And so the rules are fundamentally the same. It's just that the budgets and the scope of things are very different in podcasting. So in my book, what I tried to do is provide some information about copyrights and contracts and the disclosure requirements for advertising and FTC affiliates and all that kind of stuff, and and sort of lay out what the rules are for things like libel and slander and invasion of privacy, all the kinds of things that journalists and broadcaster media folks need to be aware of and tuned into. And I tried to sort of lay it out as a series of sort of best practices for podcasters to adopt and make it as easily read and accessible. It's a summary, of course, of
right.
Called the Podcast Blog and New Media Producers Legal Survival Guide.
One question as a podcasters always have all the time is the music. What's the convention on using music in a podcast?
Well, the conventional wisdom and the law are very different. The conventional wisdom is to be able to use anything I want.
Right, yeah.
That's not the way it works. Basically, if you don't own what you're putting into your show, you are going to be stepping on somebody's rights. And when somebody sits down and writes a song, that is their creative effort, and they are entitled to own the results and proceeds of that creative effort. And then when they make a deal with a record company and they go and record that song, the record company has a right to own and exploit and receive the results and proceeds from that recording session. And so it owns a copyright in the recording. So right away with music, you have two copyrights, the composition and the recording the composition. And you have to go get permission from both when you're, recording into a new medium. You're doing what's called creating a derivative work because it's derived from those original things. So a lot of permission and licensing is required. And unfortunately, we're in a stage right now where there is no simple one-stop shopping approach to this. So you really have to go get permission for each piece of music. The one exception that everybody knows the name of is called fair use. And that is a free speech, accommodation in the copyright law that basically says that, certain kinds of small amounts of use in certain kinds of contexts that transform the work and aren't expressly commercial and going to hurt the market for original, those might be okay. But that's something that's determined on a one-off basis. Every single fact scenario is going to be looked at differently, and Don't use music in your show unless it's been written specifically by or for your show, or it's labeled as pod safe or royalty free or something like that.
Okay, so like places like, like Themes Forest and Envato, they all have like music channels and you can use those, or Sound Bakery. Okay, cool.
You have to carefully read the license agreements, because sometimes it'll be you're allowed to use it in one thing. Each time you pay for the license. Well, if the one thing is one episode, you've got a problem.
Well, that's good to know.
Yeah.
There's always that fine print. Now, let's talk a little bit about kind of the law in terms of writing. What are some areas of law that writers and authors need to consider when they're starting their businesses?
Well, certainly copyright is an important consideration, both on the coming and going sides, as you say. When you sit down and write something, just like that songwriter I described, just the act of sitting down and writing your original thoughts, your original expression of your ideas on paper or in a computer or on tape or whatever, you now own a copyright in that work. You don't have to register it. You don't have to do anything. You don't have to put any notice on it. All of those are very good ideas for a whole bunch of reasons, but the law protects you from the moment you create that work, and the owner of a copyright is entitled to the exclusive right. No, nobody else can do it without their permission, is to make copies, to distribute copies, to perform or display the work to the public, and to make those derivative works, things based on it. So it's a big bundle of rights. And so it's important to remember that when you create something, you own it, and when other people have created stuff that isn't more than, almost 100 years ago now, they own it, and you have to get their permission to use it.
With everything you write, do you have to write copy written by so-and-so? What's the best way to say that?
Well, for printed stuff, for anything but recorded work, the proper way of putting the notice on it is that little C in a circle, or the word copyright, and the year and the name of the author. So for me, it would be, C in a circle, 2017 by Gordon Firemark. And there it is. I put copyright notice on it. Like I said, that isn't a legal requirement, but it is a great idea so that people know where to find you if they want to ask for permission.
How much of someone's work can you use before you need permission? Like if someone has a cool quote on Forbes, like if I'm writing a book and I see someone's quote on Forbes and it totally fits with and jives with what I'm writing in my book, can I use that quote, or do I need to ask for permission to use that quote in my book?
There is no hard and fast rule. I wish there was, and it'd be nice and simple to be able to tell people the answer, but there is no specific rule because, let's face it, you can steal 4 notes of a song and it be recognizable as Beethoven's Fifth. Bum, 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 it doesn't take much. So, but a very short quote generally is not going to be a problem, especially if you give attribution. It's when you start to quote large passages or big chunks of the work as a whole. You have to sort of that's why I was saying the fair use thing is an ad hoc, case-by-case analysis, because we just don't know until we see it.
Right. Now, something that strikes me is when I'm working with particular authors or using reference books like religious texts like the Bible, with a book like that, I don't know if it's a trademarkable work, but it's the Bible. You know what I mean?
First of all, let's say the Bible is old enough that whoever wrote it, all of the people who wrote passages of the Bible, do not own copyright in the content of the Bible. Now, a particular publisher might own copyright in the particular way that the Bible is laid out and displayed and those kinds of things, and any added material that they've included. But even the King James version is old enough now that it's not.
Right.
It's not covered by copyright, but a more recent book certainly might be.
So it's kind of based on translation then?
Well, just generally the copyright is a limited time right. It lasts for the authors. Well, currently it lasts for the life of the author plus 70 years. So if it's old enough, you're allowed to use it. Now, the current operative date is 1923. Anything written before 1923, it's pretty safe bet that it's in the book domain and you can use it freely. It's the newer stuff that we have to figure out in each instance. And there's been a bunch of changes in the copyright law of the years. So it depends what year the thing was written. We have to figure it out.
Okay. And I'm glad you brought that up because I was in a discussion, I guess, a week ago where someone was asking about they're a children's book author and they wanted to do an adaptation of a particularly old, nursery rhyme. How, is that something that people can, because you see it all the time. You see books of nursery rhymes. You see books of old fables retold. Yep. Because it's in the public domain, can you just say, I'm going to rewrite this and re-illustrate it and put it out to the public? Is there any permission that has to be gotten with that, or?
No, as long as it's old enough that it's no longer covered by copyright, and as long as it is that you're not taking anything that was new in the particular publication that you're looking at. Because remember, you might have, the story of Peter and the Wolf, which is a very old story, but if you tell it the way it was told in an illustrated book from 1970, it's possible that they added things or changed words here and there. But you've got to be careful that you're not bringing in any new original stuff to the old. So go back to the original source whenever possible.
Oh, great. That's super advice. Now, as far as business setup, there are a lot of freelance writers who listen to the show who are just branching out, wanting to start their careers in freelance. What's the best way for them to get started with their business from a legal standpoint?
Well, the best thing you can do is get started. And there isn't any particular format or structure that's going to be perfect for every single business. Now, if you're working with another person, you're forming a partnership, and it makes sense to come to some agreements about how that partnership is going to work. Most states in the US and most countries, frankly, have a default set of rules that says, look, if two people form a business together to make a profit, then they're going to be deemed equal partners unless there's a document or some evidence that intended something different. And that means they'll have equal voting control, equal rights in the profits, and equal liability and responsibility for the losses of the company. So get a written partnership agreement if you're working with other people. If you're an individual or if you're working with other people, you may want to look at whether forming a corporation or limited liability company makes sense. Generally, there's taxes involved in that, and obviously some legal expense in forming the entities. And so a lot of companies sort of wait until they're sure they're up and running,
Right.
Fraction before they do it. It's a great idea to do it early if you can, and definitely want to talk to someone like me to get some, custom tailored advice on these kinds of things.
And speaking of that, when it comes to freelance writers who are working on a contract basis, like, a company reaches out to you and says, hey, I want a contract with you. Let's write an agreement. What needs to go into that to protect both parties?
I think the way to answer this is to look at the understanding of the parties and make sure it's all down on paper and that it covers everything that would be necessary for a judge or a jury or an arbitrator or someone to be able to figure out what the parties intended. So you definitely need the who, the what, the where, the when, the how, the W's in English. Who, what, where, when, how, why, how much, all those kinds of things. Who's responsible for which aspects of things, and anything that's left ambiguous that could be a problem will be. So, there are template agreements for things like designers and freelance writers, things like that. And it's great to start there. But, basically a contract is formed when people come to an agreement. And so as long as there's nothing open so that we can, if we can argue that there was never a meeting of the minds, then there's no contract. But as long as the parties have come to an agreement, the contract is there and it'll be binding insofar as the person you're asking to decide can figure out what the parties want. Otherwise, they end up inferring or just using generally accepted principles, and that may not be what everybody agrees to. So longer, more comprehensive agreements, I would say, are better, but sometimes it's nice just to have a single sheet of paper saying, yes, we actually agree.
Right. So with that, for creating contracts, do you recommend that people consult directly with an attorney, like someone like yourself, or because I know LegalZoom, you have all these online services, but of course, you're dealing with your own jurisdiction, your own state laws. How does that work?
Well, I think the short answer is yes. I would prefer that, at least for deals that have some real significance in your life, your business. You're going to take it seriously enough that you will go and get custom legal advice for the specifics that you're dealing with. I like to analogize. You mentioned LegalZoom, these other online services that are sort of form filling services and so on. Think about it this way: if you're walking down the street and you need a haircut, right? You walk down the street and you see a box. And there's a hole in the bottom of the box and it says, haircuts, $5, insert head here. Are you going to do that? Or are you going to go to the salon across the street and pay $25? Because, it's just the risk. Yeah, you might get a great haircut and you also might lose your ears. So are you going to do that with your business? You should take it at least that seriously. That's how I view it.
That's a great analogy. Yeah, I definitely don't want to get the haircut in the box.
If you had a look at me, you might realize that I probably did. I have a shaved head, so.
So with an author who's pursuing publishing, there's a lot of authors who want to pursue publishing. They want to work with agents. They want to deal with publishing companies. And of course, you have publishing companies out there who they all vary from publishing company to publishing company. Should a writer who gets a contract or a deal from a publishing company, what should they look for? Two, should they consult with an attorney prior to signing the contract if there are things they're just simply not sure of? Or
to answer the question, should a writer consult an attorney before signing a publishing agreement? I'd say absolutely yes. I think it would be a fool not to, even if you have an agent who knows this business and is reviewing and reading the contract for you. It would be foolish not to have an attorney as well who, we lawyers and agents, we have different roles. The agent is a sales representative, and it's their job to find the deal and make it happen, and they're interested in making it happen quickly. And let's face it, they're getting paid a percentage of the deal, so they want to see it close. And they may be very interested in the money side of the deal. But, what happens later with the copyright and who controls what aspect of things may or may not be high on their list of priorities. And so, let's face it, you've spent, weeks, months, years writing your book, writing whatever it is you're doing. You've poured your blood, your sweat, your tears, your heart, your soul into the work. It's your creative output. It's your baby, right? And it's about to be born. You don't have it be born and then hand it over to someone and never see it again, right? Never see
right.
Or have an influence over it again. So, and that's what a lot of publishing deals do is, you're handing over your baby and they're going to take it from here for years and years, if not for life. And that may not be what you have in mind from a publishing deal. And the money may be nice, but there are other aspects that need to be reviewed. And we lawyers are good at spotting all those things. So that's my advice.
Yeah, no, it's just that always that giddiness of, whoa, I got this deal. So just making sure that in your excitement, you protect yourself.
Now, let me just say also that it's very exciting, but every deal I've ever seen from a publisher, from a television studio, movie company, whatever, there's always something that can be improved. Maybe not in the bottom line dollars and cents, but in the way they report to you and how often and what they are allowed to deduct before they send you your share of the money. All those kinds of things can be negotiated and discussed. And one thing I will say is anytime someone presents a deal to you that says take it or leave it, that's a sign that you should probably leave it. That's my
Whoa, absolutely. Now, for nonfiction authors who are writing life stories, they're writing memoirs, they're recounting events as they recall them. How do they tell their story, which of course they deserve to tell their side of any story? How do they tell their story but protect themselves from liability or lawsuit, by mentioning other people or whatever the case may be?
Well, first off, I'm going to cover a bunch of different bases. So for copyright purposes, facts are not something that are protectable. So real events that happen, you're allowed to tell those. As long as you tell it your way, you're allowed to do that. But your way has to also be true. So if you're telling stories about other people, as long as it's true, you're fine, because libel is the printed, published version of what we call defamation. Slander is the oral version. So if you and the definition of these things is a false statement made about someone that hurts their reputation and causes them harm. So if it's true, it's necessarily not false. So it's not going to bring any liability. Now, it's possible that if you're telling, a story of someone's very private life that isn't public knowledge or out there for people to know about, you could be invading their privacy in some way or something like that. And you just sort of have to judge, is this really something that's embarrassing to them and that they've made efforts to keep private? Things like sexual history, sexual orientation, medical stuff like that. That's stuff education. That's stuff we consider private. But if it's generally, either public knowledge or not embarrassing kind of stuff, you're not invading their privacy. You're not. You can't, you just don't want to present them in any way that would give a false light, a false impression, or be actually false about them. And then you're pretty good. When you're doing stories about real people, it's sometimes worthwhile to get them to sign a contract that gives you the right to tell their story. In the movie and television business, the writers often like to elaborate and expand things or create a scene in the bedroom where there's no way anybody heard what was said between husband and wife, but you want to create that scene to make it authentic and real. And let's face it, you're making up the dialogue, right?
Right.
So it's false. It may be false. So getting their consent to do the life story, right? We call it a life rights deal. Basically, their promise not to sue you and to cooperate with what you're doing, and to get others to cooperate, and often provide stuff that you need, interviews and photographs and those kind of.
So what happens in a situation where someone says, well, I don't exactly remember it that way, and so I don't want you to tell that part of the story or my part of the story, but it's something that you as the author vividly remember. Is there any language that needs to be structured within the writing that says, hey, this is my recollection of the event, or as I remember, or?
Well, when you're telling it in the first person context like that, and you're saying, here's the way I saw it happen, or here's what that's usually going to be enough, because it's sort of disclaiming that, there might be other interpretations. Again, if it is really objectively false, then even though it's the way you remember it, you might be liable. So you just have to be careful. And so you want to evaluate, is this a damaging thing? Am I painting somebody else in such a bad light that they're going to want to sue? And if so, then, try to verify that it happened that way from some other sources. That's generally a best practice anyway, is if you're telling a life rights, a real life story, try to corroborate things by, from 2 or 3 sources for each, important statement that's being made.
Now, what are some other areas of law that you work on with regards to protection for writers and authors, or even screenwriters?
Well, we've heard a lot of it. Obviously, the deal-making aspect of things is something that I'm adept at, but also the business structuring, corporations, limited liability companies, and a lot of times artists should consider doing that when they get into the early low 6 figures of regular annual earnings, because there's some tax benefits to that. So forming what we call a loan-out corporation or personal services company is sometimes a good idea. Less so probably for authors of books and things, but it's still something to consider. What else? Trademarks. If you have brand names that you are wanting to protect, generally the title of an individual work is not something that will protect by trademark law. But if it's a series of books that you're doing, for example, Harry Potter and the that is something we can trademark and prevent others from writing the Harry Potter the Harry Potter specific thing. Likewise, the characters in a story might be something that you can protect both with copyright and trademark. So I'm trying to think, what else do I do in my daily practice?
Well, you brought up something really cool there that I'd love for you just to talk about really quickly, is just titling. Because I think a lot of authors stumble on titling. They're like, I want to title my book this, but I saw another book in Amazon had the exact same title. And you mentioned, of course, series of books can be trademarked, but individual titles. What about individual titles?
Well, an individual title, to the extent that it's a distinctive name, getting there first basically gets you a certain amount of rights. But under U.S. federal trademark law, the trademark office just won't register a trademark for a single work title. So if you have a song or just a single book, you're not going to get a trademark for it. So you're going to be relying on common law trademark and the law of unfair competition, which is more state law kind of thing, to protect you against somebody coming along and adopting the same title for the book. But let's face it, people adopt titles that have been used before, and you have to set your book apart. Let's face it, the name of the author is another distinguishing factor, right? So I wouldn't get too hung up on this particular issue until you start creating a real brand around a particular book or character or something like that. So I think of the, what's his name? John Sanford writes a series of books where he has a character named Lucas Davenport. And, if I wanted to create a Lucas Davenport story, I probably could do so, but if I'm conveying that it's the same Lucas Davenport and it's sort of done with the approval of Sanford, now I'm crossing a line, and so it might make sense for an author in that scenario to register trademarks for the particular character names, particular titles. If all of his books use the word prey in the title, and so it wouldn't surprise me to find out that he's registered the prey as a indicator for books.
Okay, cool. Now, I want to jump over to one other group because, I'm being a journalist, I work with a lot of, I talk to a lot of journalists and being a part of the society. And something that comes up a lot is when you pitch stories? Like, what can journalists do to protect themselves in situations where they're pitching stories to different publications and then seeing their story ideas in a particular publication from what they pitched?
Let's talk about it a little more broadly. So how does a journalist protect against having a pitch idea or concept stolen and used by the recipient of the pitch? Well, first of all, like I said, facts not being protectable, ideas are also not protectable. What copyright law protects is the particular way you express your ideas. So for the example that I look at, it's actually a true event, the gunfight at the OK Corral that happened. It's been retold in countless different books and stories and movies and magazine articles and all of those kinds of things. And each time it's told from the particular point of view that author or that writer has taken. And that's fine, or that filmmaker, whatever. As long as they're not copying the exact same structure and phrasing and words that are being used to express the facts of the corral, the gunfight at the OK Corral. So ideas versus expression. It's the expression that's covered by copyright. What can help you in this situation where you pitch something to an editor or publication is the law of contract. Now, you probably going to have a written agreement with the editor saying, hey, I'm coming in to pitch you a story and you promise not to use it without hiring me to write it. But that's sort of the implication that should exist anytime you go to do a pitch or send, so you don't send a blind email. Hey, what about this? Start by, hey, can I send you a pitch with the understanding that if you're going to use it, I'm going to write the thing. Then when they say, sure, what do you got? That's when you send the pitch. So you add a step to the equation, get them to agree to the implied term that you're going to be hired to write the thing. Okay, that's one approach. The other is sit down and write the piece first and sell it as a spec piece rather than selling a pitch. And that way you've got your particular expression of the idea. There's still nothing to stop them from saying, oh, we love the idea. We don't like your writing. We're going to find someone else to write a story about this same topic.
Right.
Sorry, there's nothing you can do.
Right. Now, in situations like that, I mean, let's use an extreme situation like that, where you send something, they say, yeah, we'll take the pitch, we accept it, blah, blah. You send the pitch, they decide, well, yeah, I really don't like it, but we'll have somebody else write it. Thank you very much. With our emails, like in situations like that, are emails legally binding to certain things where they've said, hey, we're going to do this.
Yeah.
But we've changed our mind. We don't want you to do it. Huh?
Right. Even an oral contract is binding. And when you have the emails back and forth, assuming that they actually do indicate, again, we're talking about what contract is, a meeting of the minds about the essential terms. So if it's essential to you that you're not going to show them this pitch till they agree that you'll be paid for it if they decide to use it, or that you'll be hired to write it if they decide to run with this idea, then the email back saying, yes, we agree to your terms is you formed a contract. And there's no law that says it all has to be on the same piece of paper signed with wet blue ink. So, you've got a contract. And those emails will be the evidence to prove the existence of that contract. Now, the real trouble in that scenario is their story really the same idea as yours, or does it really just sort of fall under a broader umbrella heading of politics, or something like that?
Right.
And that's the stuff that you end up fighting about in court over these things. And unfortunately, there's just no way to cover every little bit. So really, the answer is do business with reputable people. Don't do business with scumbags that steal from people. That's what I would say.
Awesome. All right. Well, is there anything that we did not cover? I feel like we've covered a lot. We've covered various aspects of writers and writing. Is there anything that I missed that you want to fill in any holes or?
I think you've done a great job interviewing me. The only thing you haven't asked me is where people can get my book.
Oh, that's the next question. I just want to make sure that we had no more writing-based questions.
No, I mean, we'll say, by the way, anybody who wants to can reach out to me on the web. Firemark.com is the website, and I have a YouTube channel at firemark.tv where I answer lots of questions. You can even submit questions for that at firemark.com/questions. Now I'm throwing out all this word salad of URLs.
And the book is available on your website as well as Amazon?
Actually, the book is at podcastlawbook.com. It's an ebook. It's not available. Well, actually, it is available on Amazon. I take it back. So you can Google my name or search my name on Amazon. You'll find it, or podcastlawbook.com. And it's great for bloggers and videographers as well.
And you also have a podcast as well, correct?
I have a whole bunch of podcasts.
And do your podcast cover like kind of the legal advice and some of the things that we cover today?
Yeah, so Entertainment Law Update is actually a monthly roundup of legal news in the entertainment and media fields. Co-hosts and I get together and we look over the cases that have come out in the last few months or the last month, and we talk about them for an hour. And then the other one that might be of interest is called Entertainment Industry Insights, where I talk to thought leaders in the entertainment industry just about where they are now and where they think the industry is going.
And I did have one question I didn't get to that I want to ask you. Can I ask you really quickly?
Of course.
All right. When people write biographies or unauthorized biographies, like I would decide I wanted to write an unauthorized biography of Steve Jobs, how does that work legally where you can write a biography about somebody and it's cool?
Well, you don't have any legal right to stop people from telling true stories about you. It's not defamation. If it's public information or easily found information, it's not private. There's no violation of privacy. And there's another notion called the right of publicity, which is the right of a person, sometimes just a celebrity, depends on what state you're in, but generally the right of a person to control commercial uses of name and likeness. Well, writing a book about a person, a biography, is not a commercial use. So we don't have to worry about that. So as long as you're not, injuring somebody's reputation by telling lies about them, you're fine. And that's the whole, and frankly, sometimes the unauthorized is the best selling point for these books. So you can do that fairly freely. If you're really concerned about it, getting the cooperation of the person is worth doing. And that means sharing the money and giving them some rights and those kinds of things. But unauthorized biography are legal.
Awesome. No, that was I was like, man, that's the one question I needed to ask you before we left. So thank you so much. You covered a lot of things. You've done a fantastic job. Thanks for joining me today and, for sharing how people can access you. And man, there's so much to the legal side of things, that I think as writers, we don't think about because we're so much on the creative side.
Well, yeah, that's why I have a job.
And thanks for all you do.
Thank you, Chris.
But thanks for joining me today, Gordon. And we'll talk to you soon.
My pleasure. Thanks.
Hey, author. Chris here. I want to tell you about a program that I'm really excited about called Group Gold. For a long time, I would post on my Facebook fan page only to find crickets. Very few interactions, very few connections. That is before I discovered Facebook groups through the program Group Gold. Facebook Group Gold program is the most complete one of its kind to help you grow, engage, and monetize your Facebook group. Mark Mawhinney, the program creator, will walk you through every aspect of how to create, manage, and run your Facebook group so that your tribe is coming to you. Makes it easier, doesn't it? When you've got people interacting with you because they want to be there. That's the beauty of Facebook groups over Facebook fan pages. Ever since I started the Facebook Group Gold program, I've been growing my group, building my audience, and I've got people in there who are active and who want to be there, hanging out with me every single day. You can have that too. Just visit my website, www.readywritelaunch.com, and under the offer tab, select Group Gold. Then you can see for yourself the magic of Facebook groups.